Good morning and welcome to the Public Service Commission of South Carolina. It is Wednesday, September 8th, and we are here for oral arguments today. I'm going to recognize Attorney Stark to read the docket, please.
Thank you, Madam Vice Chair. Madam Vice Chair, other commissioners, we're here for the oral argument scheduled for today, September 8th at 12:30 p.m. in the...
That's fine. Please go ahead, Mr. Stark.
It's been scheduled at 12:30 p.m. virtually. This concerns docket number 2019-226E and docket number 2021-9E, both of which concern Dominion Energy South Carolina Incorporated's prospective procedural schedule on their IRP proceedings.
Okay, thank you, Mr. Stark. We'll take a roll call of the commissioners at this time. Present in the hearing room is Commissioner Carol Williams and myself, Vice Chair Belser. Appearing virtually, we have Commissioner Irvin, Commissioner Powers, Commissioner Caston, and Commissioner Thomas. I note for the record that Chairman Williams is absent today on leave. And now if we could take a roll call of the parties, if we can get those up. Bear with us a second. Who's appearing for the Office of Regulatory Staff, please?
Good morning, Madam Vice Chairman, members of the Commission. Appearing on behalf of ORS is myself, Andrew Bateman. I also have Mr. Alex Knowles with me in the room. Thank you, Madam Vice Chairman, members of the Commission.
Thank you, Mr. Bateman. Appearances for Dominion Energy South Carolina.
Good afternoon, Vice Chair Belser and members of the Commission. My name is Chad Burgess. I'm Corporate Counsel for Dominion Energy South Carolina, and with me today is President Ziegler from the law firm of Womble Bond Dickinson. Thank you.
Thank you and welcome. Appearing for South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good afternoon, Vice Chair Belser, members of the Commission. This is Kate Mixon on behalf of Southern Alliance for Clean Energy and South Carolina Coastal Conservation League. And also with me today is Emma Clancy.
Thank you, Ms. Mixon, and welcome. Appearing for Carolina's Clean Energy Business Association.
Vice Chair Belser, members of the Commission, I'm Richard Witt from the Witt Law Firm here for Carolina's Clean Energy Business Association.
Thank you, Mr. Witt. Welcome. Sierra Club.
Yes, thank you, Madam Vice Chairman and members of the Commission. This is Dorothy Jaffe on behalf of the Sierra Club.
Thank you, Ms. Jaffe. Welcome. Johnson Development Associates Incorporated. Okay. And South Carolina Department of Consumer Affairs. Okay, thank you. Mr. Bateman, I believe this was ORS's motion. Would you like to proceed at this time, please? And even if you don't like.
Absolutely, Madam Vice Chair. Thank you. Madam Vice Chair, members of the Commission, the Commission issued a procedural schedule and hearing dates and Dominion's IRP update. I believe it's docket 2021-9-E. The statute contemplates that the utility file an IRP update annually, that some period after that IRP update has been filed, ORS file a report with the Commission, and the Commission then, upon review of the utility's IRP update and the report, issue a decision either to approve or recommend. It says that the statute, and this is 58-37-40D, states that after reviewing the annual update and ORS's report, the Commission may accept the annual update or direct the electric utility to make changes to the annual update that the Commission determines to be in the public interest. Based on the language in the statute, Madam Vice Chairman, ORS filed this letter informing the Commission that ORS plans to file its report 120 days from the date on which Dominion filed its IRP update. ORS felt it was necessary to file this letter and inform the Commission of ORS's plan as a result of the procedural due dates and hearing schedule that the Commission had published. To the extent the commission believes a hearing is required, it may make sense to have that hearing subsequent to ORS's report being filed with the commission. And for the aforementioned reasons, Madam Chairman, we would request that the commission modify its procedural schedule.
Thank you, Mr. Bateman. And I believe that the commission directive from last week held that pre-filing dates and the hearing date in abeyance. Is that correct?
I believe you're correct, Madam Vice Chair.
Okay, thank you. Commissioners, any questions for Mr. Bateman? Commissioner Carolee Williams?
Thank you, Vice Chair Belzer. Mr. Bateman, thank you for bringing this to our attention. I think that part of the Commission's interest was in a matter of timing and keeping these plans as current to date as possible. And so with that in mind, I am curious how you determine the 120 days. I don't think that's in the statute, but want to certainly just want to understand what the components were for your determining the up to 120 days. And what you just said, I think, was filing 120 days after the Dominion IRP was filed.
Yes, that's exactly right, Commissioner Williams. I appreciate the question. And I believe you're correct that the statute does not require that the report be filed 120 days. I think, in fact, I believe the statute does not mandate any timeline in particular. ORS landed on 120 days because this is a complex matter. It's a complex matter that requires at least one, maybe multiple rounds of discovery. It requires a complex review of a complicated analysis. There are a number of factors that the statute outlines ORS is to look at when it's reviewing the company's IRP update. So while I absolutely understand the Commission's concern that the IRP update and ORS report be as temporally close as possible, with that in mind, a reasonable deadline that the experts here at ORS settled upon as being one which we could meet to file a thorough, well thought out and meaningful report for Commission consideration was 120 days from the date on which the company filed its IRP update. Oh, I'm sorry, Commissioner Williams.
Thank you, Mr. Bateman. No further questions.
Now I'm off.
Madam Chair?
Is that Commissioner Urban?
Yes,
Commissioner Urban, please go ahead.
thank you. Mr. Bateman, good afternoon.
Good afternoon.
I understand that as part of your motion, you advised the commission in your letter that you have outstanding discovery requests that you've already served on the company. Is that correct?
Yes, sir, that's correct.
And has the company indicated when they might be able to respond, or have you heard back from them as regards to your discovery request?
Commissioner Urban, I don't, off the top of my head, recall the date on which we requested that responses be due back to ORS, though I believe we gave the company a reasonable amount of time. We had a number of questions, as I mentioned earlier. It's a complex analysis, so we did have a number of questions for the company. I believe, from my understanding, they are working to answer some of the questions early for us. On those other questions, I don't believe we have a response yet, though I also, in the same breath, do not believe that the due date has come and gone yet.
Did you consider discussing a proposed procedural schedule with the other attorneys, and so that you could give us some guidance or recommendation as to how much time everyone will need to complete the various requirements of Act 62 regarding the IRP update?
Commissioner Urban, we did not consider discussing a proposed procedural schedule with other attorneys, and we did not discuss a proposed procedural schedule with other attorneys. While ORS has no opposition to the extent the Commission believes procedural schedules such as testimony deadlines and a hearing may be required, a plain reading of the statute specifically doesn't contemplate that there are testimony deadlines and a hearing date. And for that reason, we didn't discuss that. Though, as I mentioned, to the extent the commission believes it's in the public interest, ORS certainly wouldn't oppose.
Because it appears from the responses that were filed, most, if not all, of the parties are in agreement that more time is needed to complete discovery. Is that true?
But Commissioner Irvin, while I certainly don't want to speak for colleagues from the other parties in this case, I believe that to be true based on the representations made in their letters.
And common sense and reasonableness and fairness would dictate that you want to have sufficient amount of time to complete discovery in order to have a meaningful report to file. True?
Absolutely, Commissioner Irvin. In order for ORS to file a meaningful and thorough report, we certainly need the opportunity to conduct discovery, to review those responses, and maybe even follow-up discovery, depending on what those responses state.
So is it your representation that it would not be in the public interest to kind of short shrift or rush the process simply to get to some result without the opportunity to complete adequate full discovery is needed, correct?
Mr. Chairman, I'm hesitant to state what may be in the Commission's purview as the definition of its application of public interest, though I can state with certainty that ORS cannot conduct a thorough and well thought out and meaningful analysis in a time period less than the 120 days that we believe is reasonable to file that report.
Thank you, Mr. Bateman.
Yes, sir.
And Madam Chair, if while I've got an opportunity to ask questions, would it be appropriate to wait for the others to make the presentation or ask some questions now?
Commissioner, we were going to have the opportunity for questioning of every party after they make their presentation.
Thank you. That's all I have for Mr. Bateman. Thank you, Mr. Bateman.
Thank you,
Thank you,
Commissioner
Commissioner.
Irvin. Any other
Madam
commissioners?
Vice Chair, this is Commissioner Thomas.
Please go ahead, Commissioner Thomas.
Thank you. Good afternoon, Mr. Bateman.
Good afternoon, Commissioner Thomas.
I just have one question. Does ORS prefer a formal hearing or a paper hearing?
Commissioner Thomas, similar to Commissioner Irvin's question a second ago, to the extent the Commission believes it to be in the public interest to have a formal hearing, ORS certainly wouldn't oppose, though a strict reading of the statute does not evidence that the General Assembly required or contemplated a formalized hearing in this proceeding.
Okay, thank you. That's all I have.
Yes, sir.
Thank you, Commissioner Thomas. Any other commissioners?
Madam Vice Chair, this is Delton Powers.
Please go ahead, Commissioner Powers.
Thank you very much. Mr. Bateman, I too just have a couple of questions. And I think we on the commission are certainly trying to keep moving forward as quickly as we can. I feel like we've kind of been in a hole and want to get caught up. We're talking about an update. We're really talking about any changes that need to be reviewed. Some sort of transparency. Is there some way Dominion could outline these changes and possibly save review time and transparency for everybody to move at a quicker pace, or has there been discussion between the parties to push this discovery?
Commissioner Powers, I appreciate the question. I certainly can't speak for Dominion as to whether or not they can provide an outline in addition to the IRP update. The discovery that we have issued, I will state, is substantial. It is reasonably calculated to elicit information that's necessary for our review of a complicated analysis. I have not, from my understanding, I have received no word that any party is dragging its feet, for lack of a better word. So I don't know that it can be sped up. I do know that our experts state that it'll take a good 4 months to really churn out a quality, comprehensive, and well thought out report.
Would it be helpful if this commission possibly requested some sort of outline or some sort of help.
Mr. Commissioner Powers, again, I can't say that it would hurt, but I also have heard no indication that there is any data in the company's IRP update that could be better summarized such that it would expedite the process.
Okay. Thank you very much, Mr. Bateman.
Yes, sir.
Thank you, Commissioner Powers. Commissioner Caston, did I hear you?
Yes, ma'am, if I may ask a question.
Please go ahead.
Afternoon, Mr. Bateman.
Good afternoon, Commissioner Caston.
Can you hear me okay?
Yes, sir. I hope you can hear me.
Mr. Bateman, can you hear me?
Yes, sir. Can you hear me?
Commissioner Caston, can...
Yes, sir, I can.
Okay.
Yes. Do you have an opinion why ORS is directed to provide a report for the annual IRP updates and not the three-year IRP?
I'm sorry, Commissioner Caston. I'm not sure I could speculate as to the intent of the General Assembly.
Okay. But you do agree that ORS is required to provide a report on the annual updates?
Absolutely, Commissioner Caston. 583740D explicitly states in subsection 2 that the Office of Regulatory Staff shall review each electric utility's annual update and submit a report to the Commission providing a recommendation concerning the reasonableness of the annual update.
And if I understood you in your response to Commissioner Thomas's question relative to any thoughts relative to a paper hearing versus a full hearing, that I understand you to say, in your opinion, the statute doesn't specify either way or anything in particular, correct?
Yes, Commissioner Caston, that's correct. I believe a strict reading of the statute does not make mention of a formalized hearing, nor does it require a formalized hearing or testimony due dates. So that being said, should the Commission believe it to be in the public interest, ORS would not oppose.
Stan, what was running through my head as I was thinking about all these items during this past week or two is that now we have, I think, 4 utility IRPs, annual IRPs for each one. And what my concern is that we could have an endless array or carousel of hearings, one after another. Does that seem plausible?
Commissioner Caston, I absolutely believe that there is plenty of work to go around.
Okay. Thank you, Mr. Bateman. I appreciate it.
Commissioners, anything further for Mr. Bateman? Mr. Bateman, thank you for your presentation. We will let you off the hook for now, and I believe next and I'm going in the order that documents were filed regarding this matter. So next we would go to Dominion Energy.
Thank you, Madam Vice Chair.
Thank you, Madam Vice Chair. Belton Ziegler with the law firm of Womble, Bond Dickinson, representing Dominion Energy, South Carolina. Thank you for the opportunity to appear before you all today. Dominion Energy, South Carolina would like to make several points. First, it supports the motion that ORS has made to delay the hearing and the pre-filing of testimony until after ORS has completed its review. We believe that is the legislative intent of 583740D2, which clearly intends for the Commission's review of IRP updates to be focused primarily on the IRP update itself and the report to be issued by ORS, asking parties to file in advance of the ORS report would be disruptive and I think unworkable. Second, we support the timetable that ORS has proposed for filing its report. 4 months or 120 days is a reasonable time to conduct a thorough review of the filing, query the company on points where ORS and its consultants have questions through the discovery we've already discussed, and to undertake the very detailed and complex analyses that are required. In that regard, I would ask the Commission to reflect on some comments made by Mr. Ekman of the Lawrence Berkeley Laboratories when he and Ms. Schwartz conducted the Commission's IRP workshop back in April and then again in June. He indicated that it takes 18 to 24 months to properly prepare an IRP. Clearly, it's not unreasonable to afford ORS 4 months to conduct a review of an annual IRP. In addition, the DESC would respectfully suggest that in adopting the IRP statute, the General Assembly indicated in clear terms that it intended for the Commission to review IRP updates on a paper record without a hearing. There are both statutory, regulatory policy, and practical reasons why this is the case. With regard to the review of the triannual IRP filings, not the updates, the General Assembly clearly authorized and directed the Commission to conduct a full contested case review. The statute lists multiple defined requirements, including intervention by interested parties, setting a procedural schedule providing for discovery, permitting the filing of alternative analyses by interveners, and setting a specified 300-day time period for conducting the review. By contrast, the IRP statute clearly doesn't anticipate a hearing concerning modifications to an IRP, such as the modifications that were done at the end of last year and the beginning of this year to the 2020 IRP. In that part of the statute, it is ORS's responsibility to file a report, and other parties can submit comments, and then 60 days after the report is filed, the Commission is to issue its order. I think it's interesting where there is a hearing required, ORS is not being asked to file a report. Going to Commissioner Caston's question, that's logical because in lieu of a report, what you would have is pre-file testimony. The report is there because there's no intention for pre-file testimony in the statute. Insofar as the annual updates are concerned, annual updates like the one before you today, the statute clearly envisions that the review would take place on a paper record. The statute reads the Office of Regulatory Staff shall review the annual update and submit a report. It then states that after reviewing the annual update and the Office of Regulatory Staff report, the Commission may accept the annual update or direct the utility to make changes. No mention of any of the provisions that would apply to a contested case hearing, provisions like discovery, intervention, timetables for the hearings to take place. Clearly, the legislature intended for this to be done on a paper hearing. That's not accidental. There are sound policy and practical reasons why the legislature made that decision. To require an annual contested case proceeding each time an IRP update is filed would indeed put the utilities in an endless loop of IRP proceedings. If a reasonable time to prepare an IRP is 18 to 24 months, and a reasonable time for ORS to review one is 4 months, then, and I think this is indeed the case, it's ordinarily going to take a utility about 6 months to properly prepare an IRP for filing. If you add to that the time necessary to answer discovery from interveners, prepare direct and rebuttal testimony, prepare witnesses for hearing, conduct the hearing itself, and review the order and make the compliance filings required for the order, then a utilities planning department is never going to be able to give its undivided attention to other matters. It'll constantly be litigating an IRP. The other matters that these departments have to deal with are not inconsequential. They're avoided cost proceedings, net energy metering and solar choice type proceedings, the requirement of implementing new planning models, perfecting models, improving models, conducting load research and other improvement analyses that are critical to keeping the IRP process moving in a rational way. There's the planning and conducting of stakeholder processes around IRPs, which is part of what the planning departments do. We've mentioned load research and other inputs that have to be adjusted. In addition, these groups are evaluating emerging technologies, supporting procurements and RFPs for things like solar and battery storage, supporting the analyses for things like coal retirements, as are ongoing now, for studying the retirement possibilities for Williams and Watery. There are even episodic requirements for conducting repair replacement analyses, such as the commission considered related to the Watery Unit 2 repairs. These are all interrelated, mutually dependent exercises that depend on the same models and the same modelers, the same forecasters and the same forecasts that are at the core of an IRP process. If the people who are doing these analyses are constantly involved in IRP litigation, it's going to impact the quality of planning that can be done in other aspects of the company's work. And I think the limitation of the IRP process to the paper record is completely consistent with the purpose and function of an IRP. As the trainers from the Lawrence Berkeley Labs made clear, primary function of an IRP is to create transparency surrounding the assumptions and methods a utility uses in its internal planning efforts. The IRP process makes those assumptions and methods subject to periodic review and comment from a diverse group of stakeholders and their experts. This happens in the traditional triennial IRP proceedings and also on an ongoing basis through the extensive stakeholder process that's now ongoing between the triennial IRPs. But the IRP is not a decision-making document. It doesn't authorize any action by the utility or establish the prudence or recoverability of any investment. Investment decisions are made by utility management outside of the IRP process, and they're reviewed by this commission outside of the IRP process. These decisions are subject to full contested case review in avoided cost dockets, in fuel clause dockets, in Siting Act dockets, and in full rate proceedings. No major generation asset procurement or transmission asset procurement can be executed unless the commission approves it under the Siting Act. And customers don't pay for any investments in utility assets until they're presented to the commission and ORS and determined to be reasonable and prudent in rate proceedings or fuel proceedings. So for that reason, the focus of the IRP review, as the Lawrence Berkeley trainers indicated, should be on the specific actions to be taken in the 3-year near-term action plan that is part of each IRP. As Mr. Eckert with that group explained, commitments that can be delayed should be delayed because decisions made closer to the time of need will be better decisions. There's no need to do more with the IRP than looking carefully at the quality of the decision, of the planning, to take input on that, and then to look at what decisions need to be made in the short term. Accordingly, there's no public policy reason for turning each IRP into a full-blown contested case proceeding. In drafting Act 62, the General Assembly consulted with multiple parties, including ORS and the utilities. It was advised of the facts surrounding the IRP process, and I believe it made an intentional decision that there should not be a hearing every year, a carousel of hearings, as Commissioner Caston indicated, but there should be instead a triannual review, full contested case, and then a paper review subject to ORS's oversight in the intervening years. Now, there is an issue of statutory interpretation here. As the commission is aware, it is a creature of statute. It can only exercise the powers that have been conferred on it directly by the statutes under which it operates. There is a well-recognized rule of statutory interpretation that where a list of things is provided in a statute, the intent is assumed that the things not on that list are not included. The Latin term for that is exclusio unis est excludio alteris. To include one is to exclude the other. This statute refers to a report and a filing. It does not refer to any other process surrounding the update, and so it falls directly within that legal principle. The General Assembly, in short, intentionally did not include statutory provisions related to a contested case proceeding in the update statute. But while all that legal information is interesting, the compelling point here really isn't the law, but the policy and the practical implications of expanding the cycle of hearings. In the training proceeding I referenced earlier, Chairman Williams observed that in the course of a year, the commission went from an average tenure of 11 years to one of less than 10 months. In addition, the commission had to begin operating under an expansive new statute, Act 62, and to learn its work under ex parte rules that very much limit the information that the commission can obtain outside of hearings. DESC understands that the commission wants to do its job in an informed and responsible way. As a result, it is hungry for information and engagement. That is entirely commendable. And in response to that, DESC has sought to support the commission by providing extensive information through its formal proceedings, through the testimony that is filed, through the reports that is filed, and has sought in really a Herculean effort to meet a very challenging regulatory litigation calendar as established by the commission. As I mentioned earlier, Mr. Ekman said it takes 18 to 24 months to prepare an IRP. Earlier this year, the company turned around a major modification to an IRP, practically an entirely new IRP, in 60 days. Shortly thereafter, it produced a full IRP update with extensive changes from the prior IRP, again in 60 days, a small fraction of the time that any expert will tell you is a reasonable time to produce an IRP or an IRP update. All this was done while implementing stakeholder processes, conducting DSM reviews, litigating avoiding cost dockets, litigating net energy metering dockets, fuel clause proceedings, and multiple other dockets under Act 62. The core message DESC would like the commission to consider is that, in its opinion, the current regulatory pace just is not sustainable. Attention and resources are being focused on regulatory litigation to such a degree that the important work of managing and operating the electric system, improving the planning process, having comprehensive outreach to stakeholders is going to suffer. This will become increasingly counterproductive to the quality of utility planning and operations and the utility's overall ability to manage the system. In the end, the system and customers will suffer. For these reasons, the DESC asked the commission to carefully consider whether customers ultimately benefit from having an annual round of contested case IRP reviews, each effectively overlapping the other, with all the discovery reviews, disputes, testimony drafting, and hearing preparation that this entails. DESC believes the nature of the IRP and its function in the decision-making process does not support the continuous round of planning for regulatory purposes only. DSC respectfully requests the Commission to conduct its annual IRP update reviews on the paper record, and believes that's what the statute requires and the legislature intended. In the alternative, the company does support ORS's proposal that the hearing and other processes follow the release of the ORS report, that the ORS be given 4 months to prepare that report, and that the filing of comments should follow the same schedule as the pre-filing of testimony, as set forth in the letter that we provided in response to ORS's letter. Thank you, Mr. Chairman and members of the Commission, for your attention to these matters. That's the conclusion of my remarks.
Thank you, Mr. Ziegler. Commissioners, any questions for Mr. Ziegler?
Mr. Chairman, Dalton Powers.
Commissioner Powers, please go ahead.
Thank you, Madam Chair. Good afternoon, Mr. Ziegler. I guess I just want to ask you the same question. Is any reason Dominion couldn't provide some sort of outline, simple outline to all parties as to changes that are in the update?
Thank you, Mr. Chairman. That was our purpose and intent in the drafting of the IRP update, and the language there, which walks you through the various analyses that were done and the results, is intended to provide a guide to what was changed and what is different. We have an appendix to the IRP that gives a cross-reference to the specific requirements of the Commission orders as far as modifications to the IRP. We could create yet another document, but I'm not sure that it would not be duplicative of the material that's already in the record. There's only been one piece of discovery that's been filed, and that's the ORS discovery. We checked, and it's due on the 13th of this month, and work is underway to get that information completed and in ORS's hands as quickly as possible. Having taken a quick look at the discovery, it's asking for follow-up questions that dig deeper into issues that where ORS wants more information or updates, but doesn't show that ORS is at all confused or unclear about the changes that were made in the IRP. I just don't know that sort of additional guide would be helpful to the process.
I guess what I want to say is I encourage discovery to be timely and open and transparent, and hopefully we're all at the same goal. We want to get caught up, and we're just not doing it right.
Correct. Well, one of the things that was done, and it was in response to some concerns the Commission raised in the last IRP process, was that at the time the IRP was filed, the company opened up a SharePoint site and loaded into it all of the backup documents that all the specific runs and spreadsheets for the tables and the analyses in the IRP, and then immediately gave access to that body of very detailed information to all the people who had been interveners in the triennial IRP process. So we're doing, the company's doing what it can to expedite discovery and to expedite transparency. The company really doesn't have any interest in people not getting this information. What they've done is open for review. We understand that's what the IRP process is about. But there's always going to be someone who wants to go deeper on a particular issue, someone who wants to try a different approach, and that's what the discovery typically is about, not simply showing what the company has done.
I certainly appreciate your explanation and your hard work. Thank you, and thank you, Vice Chair.
Thank you, Commissioner Powers. Excuse me, Mr. Ziegler, I didn't mean to speak over you.
Same here.
Other commissioners with questions? Okay, hearing none. Oh, Commissioner Caston.
Thank you, Madam Chair. Afternoon.
Mr. Ziegler, can you hear Commissioner Caston okay?
I can, not terribly forcefully, but I can hear him, I believe. I'll let you know if I can't, Commissioner Gaston.
I will speak more loudly. How is that?
That's very good. Thank you.
Taxing, but I'll do it. Reading through the statute, the IRP annual update must include. I'm going to read these things. It says it must include, and tell me if it's right, wrong, if I left out anything, or it must include utilities-based planning assumptions, including energy and demand forecast, commodity fuel price inputs, renewable energy forecast, DE and DSM forecast, retirement date changes, other inputs PSC deems in public interest. Is there anything I left out?
That, I don't have the statute in front of me, but that's my recollection of what the statute says.
So the annual update, in essence, updates the IRP on an annual basis with these items and other inputs the PSC deems in the public interest, which would also be listed. Is that correct?
Correct. And we take it that latter category are the items that the commission has indicated need to be in the updates in the orders that have been issued in the last year and a half under that statute, last year under that statute.
And I may have misunderstood, but did you say I'm trying to get my head around how long it takes Dominion, for example, okay, you have to have the annual IRP updated by X date. And if you back up from that date, how long does it take to provide or to develop that updated information?
In the ordinary course, it should take approximately 6 months to assemble all of the changes, run all the data, review the data, check this to be sure that everything is as it should be. One of the things that's been a function of what's happened over the last over the last year, is that a number of the people who are doing this work, and they're friends of mine that I've worked with for years, are terribly concerned that they're going to make the mistakes they've tried their entire careers not to make because they're moving so quickly and have so little time to check their work. And, the company has really, I think, for very good and logical reasons, tried to do everything as the commission has requested on the timetable the commission has requested. We would ask the commission to maybe take a pause and consider whether this is a sustainable pace, and to consider that if as its own trainers have indicated, it's an 18 to 24 month process to put an IRP together, then running an update and going back and recasting a number of these assumptions, running multiple analyses, running the various programs to determine risk factors and risk exposures that are required. Going through that entire process, it's logical that it would take about 6 months, about the third of the time that it would take or less to do the full report. I think we may have created the false impression that you can turn these things on and off like a light bulb. You can, in an emergency situation, do remarkable things, but we've sort of been in an emergency mode within this part of the company for going on a year. And if we have to do an annual contested case filing will basically be in that sort of a mode, I think, on an ongoing basis.
Does Dominion use these plans to design and build infrastructure?
Absolutely. It's this basic planning model that underlies the evaluation of power purchase agreements for solar, power purchase agreements for solar plus battery, power purchase agreements for battery itself, or just the purchase of the batteries by the company itself. These planning modes are used to determine how to dispatch the units. Not in the there's a short-term dispatch model, but long-term issues related to how to, when you can take units offline, what's the most economical way to sequence the planned maintenance of these units. All that is done based on the modeling that's done by this planning department. And that's why I say that, and of course, this is also done for avoided cost purposes and for all sorts of other purposes related to assessing what the cost of the utilities capacity and energy are. Because of the interrelated nature of all of this, the people who are doing the IRPs are also supporting multiple other areas within the company.
All right, I want to make sure I understood that. My experience with planning documents were they were planning documents that generally directed our planning efforts, but they weren't design documents. From those planning documents, as time approached and as things were updated and we determined we needed a plant here, a water plant here, or an upgraded line here, then we would drill deeper and do design. Did I understand you to say this was what they designed from or what they planned from?
I suppose what I would say is they definitely plan for these, from these. If new construction is required, then this plan, the planning models that are used here would then be run in real time, right at, as the time of the decision was being made. And they would be the basis of coming before the commission in a Siting Act proceeding to say, we have looked at our models and our modeling says we need to build a battery storage facility here. We need to build a new combined cycle turbine capacity resource here. So it would be the basis on which the decision was made, both as to the need for the resource and the appropriate resource to acquire. The actual design would then be another matter. That would be getting into the engineering side of the equation. There's another aspect to an electric utility operation, which is somewhat different from a water system, which is the electric system is so dynamic and is served by resources that are scattered throughout the service territory. And you've seen the map of the service territory and its resources. It's there in the IRP. Decisions are made on a daily basis as to which units to commit, unit commitment decisions, to minimize fuel costs and ensure reliability. Decisions are also made on a longer term basis to determine when you can take a unit offline for a scheduled outage for planned maintenance, and how you should structure your resources for that. Do you need to go out and buy capacity on the market? When you do that, what's the approach? These models feed into both, the forecasts and models feed into both of those aspects, which really are the sort of day-to-day management rather than either design or engineering of the system. I guess you'd call that operational management. So what feeds out of the planning department hits all of those aspects of the utilities operations. And the question is, how do they balance doing all of that with also being engaged in a ongoing sort of never-ending cycle of contested case IRP proceedings. That's the point I'm trying to put in front of you.
All right, so final question, and I think it ties into what you were just talking about, is if the schedule occurs as requested by ORS and all the statutory requirements related to that, it will put the report, comment, all the other requirements, what, roughly 6 months, plus or minus?
I think that's
correct.
I think, the commission decision, let's see, we're looking at having the report in place in December, so the commission should be in a position to take comments and make a decision within 60 days of that. So I'd assume we'd be somewhere in the February timetable when the final order was out.
And then the next annual update is due when?
We don't know. It hasn't been set. We've sort of gotten off the schedule, and we would anticipate it being a year from the filing of this one, which would be in the summer of 2022. I guess late spring, early summer.
Well, I've kicked a lot of those dates around in my head also. All right, thank you, Mr. Ziegler. No more questions.
Thank you, Commissioner.
Commissioners, any other questions? Commissioner Williams.
Thank you, Vice Chair Belzer. Hello, Mr. Ziegler. I want to follow up on Commissioner Caston's last question. I think the last thing you said is that you would guess, but we haven't established when the next update would be. But do we know when the next full IRP would be? Because that would be kind of the bookend, and I think we need to look one more year forward.
Certainly. That would be 2023. And if you go for 3 years after the filing of the 2020 IRP, that would be February of 2020.
Commissioner Caston, were you saying something? Okay. Sorry.
Not intentionally, no ma'am. Excuse me.
Thank you. Go ahead, Mr. Ziegler.
So I think counting 3 years from the last filing would be February of 2023.
Okay. Thank you very much. I think it will be important if we are looking at February of 2023, we should take that into account as well. So appreciate your sharing that. No more questions.
Thank you, Commissioner Williams. Commissioners, any other questions? Mr. Ziegler, thank you very much for your presentation this morning.
Thank you.
Let's see. Next, we have Coastal Conservation League and Southern Alliance for Clean Energy. Ms. Mixon?
Thank you, Vice Chair Belzer and Commissioners. This is Kate Mixon on behalf of SACE and CCL. I'll start by just saying that we are in broad agreement with both ORS and Dominion. We agree with both parties that additional time is needed for ORS and other parties to review the filing, conduct discovery, and prepare the report and any comments that will be filed. And we also agree with Dominion that 30 days after ORS report is filed is a reasonable period of time for Dominion and other interested parties to submit comments on the IRP update and the ORS report. The only distinction or difference in our response, which was also supported by CCVA and the Sierra Club, is that we think that while the EFA does not specifically require a hearing for IRP updates, as it does for triennial IRPs, that it doesn't have any express prohibition on the commission doing so, and that the commission has broad authority under two particular provisions of the South Carolina Code, which are Section 5827-1930 and 58-3-140 hold hearings in addition to those required by statute when it believes doing so is in the public interest. And so to be specific, Section 5827-1930 states that the commission may, in addition to the hearings specifically provided for by this chapter, conduct such other hearings as may be required in the administration of the powers and duties conferred upon it by this chapter and by other acts relating to electrical utilities. Section 58.3.140A gives the commission broad authority to supervise and regulate rates and service of public utilities in the state. And subsection E within that same section provides that nothing in this section may be interpreted to repeal or modify specific exclusions from the commission's jurisdiction pursuant to Title 58 or any other title. We think that the EFA's provisions on IRP updates set out that a paper proceeding is a default during those years. There is no exclusionary language that would indicate those provisions would alter the commission's broad jurisdiction to decide on a case-by-case basis whether a hearing would be indicated an update year. We certainly recognize the kind of practical realities that Dominion Council outlined, and we do not contemplate that a hearing would be needed for every IRP update. But there may be circumstances where a hearing might be appropriate. For instance, if the commission required changes to be made the first time in an IRP update, or if a utility made some significant change within an update year. And so in our response, we proposed one way that the commission could get the perspective of interested parties about whether a hearing might be indicated within a given year and on what specific issues that a hearing might be appropriate. And that would simply just be to have parties request a hearing and the grounds for that request in their comments filed. Ultimately, though, whether to hold a hearing would be in the commission's discretion. Based on the initial paper record, there might be issues that the commission thinks it needs an evidentiary record to resolve. And if so, we think the commission has the discretion to then set a schedule for pre-file testimony and a hearing on those issues. So in conclusion, we support ORS and Dominion's request to amend the procedural schedule to allow 120 days for ORS to prepare and file its report, an additional 3 days for parties to submit comments. Simply ask that the commission allow parties in those comments to request a hearing if they believe there are issues where a fuller evidentiary record would benefit the commission. Thank you, and I'd be happy to answer any questions.
Thank you, Ms. Mixon. Commissioners, questions for Attorney Mixon? Ms. Mixon, thank you very much for your presentation this morning.
Madam Chair, could I just get a clarification?
Commissioner Caston.
Good afternoon, Ms. Mixon.
Good afternoon.
I'm trying to hear, I have a little bit of a head cold, so it was difficult. I want to make sure I understood what you had said relative to not necessarily having a hearing for every annual update. Is that what you said?
That's correct, Commissioner Caston. Again, we think that it might be appropriate on a case-by-case basis, but there may be years where a paper record is sufficient.
And why do you think this one is not sufficient for a paper?
So we are still in the process of reviewing the IRP update. Just as ORS mentioned, it's very complex, and so that's part of the reason that we think it's appropriate for parties to be able to request a hearing in the comments that they file at a later date, because that way that decision will be able to be based on a fuller review of the update, on any discovery responses that parties have received. And so we have not yet made any kind of statement that a hearing would necessarily be required or not this year. We did note that there might be some changes that Dominion was required to make in its IRP update that could potentially warrant a hearing, but we would have to finish our review of the IRP update in order to
Sir,
turn our position on
sorry.
that. I'm finished.
So,
I'm sorry.
so relative to the pre-filing testimony prior to ORS's report, is that still what you propose or not propose that?
No, Commissioner Cassidy, we are in agreement with the Dominion and ORS that ORS should be allowed to submit its report, and then parties would file comments after that.
Okay, so if I understood you correctly, and I think I did, and I appreciate that, is that you support ORS's recommendation, waiting until that is completed, and then evaluating it at that point to determine if you think that is sufficient.
That's correct. So in Dominion's request, they propose what we think is a reasonable schedule, which would be that after ORS files its report, there would be 30 days, and then other interested parties in Dominion would be able to file comments on ORS's report and the IRP update. And our request is that parties at that time be allowed to request a hearing on specific issues if they think that might be indicated. And then the commission in its discretion could decide whether to hold a hearing thereafter or not.
And did I also understand you to say that annual updates for all 4 utilities and hearings for all those could be problematic from just a scheduling point of view, or did I not hear that?
No, I mean, again, I think we certainly understand the technical challenges of the timelines overlapping. I mean, we would be very open to working with the parties on what what an amenable schedule might be, and with the commission. This might be a case where maybe an expedited pre-file testimony schedule, if a hearing was needed, that an expedited testimony schedule could be used. We again are open to discussing what options, what the options for that might be. Certainly, like I said, do recognize that there are some challenges in timing here, but think it might be in the public interest in some circumstances to hold a hearing during some of the years.
I understand. Thank you so much, Ms. Nixon.
So,
More questions?
Thank you, Commissioner Caston. Any other commissioners?
Madam Vice Chair,
Commissioner Irvin?
thank you. Ms. Mixon, I think you have an excellent solution to this motions hearing, and it sounds to me like it's a very reasonable way to proceed. I suppose it's possible that after the discovery's been completed and the report's been filed, that all parties could be satisfied with the final result, and there'd be no need for a hearing, correct?
yes, that's right, Commissioner Irvin. Thank you.
So it's really premature for the commission to try to set a hearing schedule or a pre-file testimony schedule at this time. Would you agree?
Commissioner, yeah, we agree. I think, you know, certainly we found the timeline in the initial scheduling order to be difficult given the kind of complexity of the issues here, and would appreciate having, you know, more time to review, conduct discovery, and then determine again what issues, if any, that a hearing might be indicated for.
And the advantage of your approach that you suggested would also limit the scope of the hearing too, and that could be a time saver. If the commission in its discretion decides to hold a hearing, at least you've narrowed the issues which you could not agree upon. True?
Yes, Commissioner Urban.
Which would be a good use of our time, and instead of having a full-blown hearing, you perhaps could limit the issues to one or two, and that would abbreviate the proceeding, perhaps.
Yes, we would hope so, Commissioner Urban.
All right. Well, I realize we haven't heard from all the attorneys yet, so I don't want to jump the gun, but I'm going to make a suggestion. I'm not going to make a motion, but I'm going to make a suggestion that perhaps you could draft a proposed order for the other attorneys to consent to. If they all are in agreement with your proposed schedule, it seems to me that I would encourage my fellow commissioners to accept that because I think it's reasonable. We want to expedite the proceeding, but we don't want a product in the form of an updated integrated resource plan to be inaccurate or incomplete. And so this preserves and promotes both a plan that we can all point to as a great work product resolution of all issues. At the same time, it expedites and promotes discovery in a reasonable time frame and gives the parties an opportunity to fully flesh out the factual issues in dispute. So perhaps you can circulate a proposal to after we've concluded the hearing today, and if it comes to us in the form of a consent order, at least we have something that we know everyone has agreed upon. So it sounds like that might be a way to move things forward. Thank you very much.
Thank you, Mr. Urban. We have coordinated to some extent, or again, got a sign off on this approach from Sierra Club and CCEVA. We've not coordinated with ORS or Dominion yet, but we would be happy to circulate something to that effect.
Thank you.
Any other commissioners with questions for Ms. Mixon? Ms. Mixon, thank you for your presentation today.
Thank you.
Let's see. Next is Carolina's Clean Energy Business Association. Mr. Witt.
Vice Chair Belser, members of the commission, Richard Witt. We have brief comments today because my client CCEVA actually joined in the correspondence that Attorney Mixon sent the commission on August the 30th. So we certainly join in and support that correspondence. And we further just support her argument today, which we're in agreement with. And I would point out one thing, Attorney Ziegler correctly pointed out that the commission as a state agency only has that authority that from the General Assembly. And as Attorney Mixon pointed out, there's a code section and there's a reg that specifically give this commission the ability to hold additional hearings when it's in the public interest. So we'd simply support what Attorney Mixon has done today and ask that the relief that we've requested jointly with CCL and the Sierra Club be granted. Thank you, Vice Chair Belson.
Thank you, Mr. Witt. Commissioners, are there any questions for Attorney Witt? Hearing none. Thank you again, Mr. Witt.
All right, thank you.
Do any of the parties have anything else to present to the commission at this time?
Yes, this is Dorothy Jaffe on behalf of Sierra Club.
Oh, I'm sorry, Ms. Jaffe. Thank you very much. Ms. Jaffe, you're recognized. Please go ahead.
Great, thank you, Madam Vice Chairman. And similar to what you just heard from Attorney Witt, the Sierra Club does agree and support the request of SACE and CCL, as articulated by Ms. Mixon just a few minutes ago, that more time is needed to review the 2021 IRP update, and that parties should be allowed the opportunity to request a hearing or oral argument on discrete issues. But in addition to that, Sierra Club just wanted to bring to the Commission's attention that there are a couple of overlapping dockets that are currently pending that also relate to Dominion's 2021 IRP update, and that would be the Lake Facility or CP Plan docket, number 2021-93E, which is currently in abeyance until mid-October, and then also the coal retirement docket, which is number 2021-192E. Now, Mr. Ziegler alluded to both of these when he referenced the RFPs for both the CP plan replacements and the Watery and Williams retirement, both of which are discussed in the 2021 IRP update and the modeling that was done. So if the commission grants the party's request to allow more time to provide comments on the IRP update, we would also ask that you take under advisement and seek input on what the appropriate sequence of the other two related dockets should be with respect to testimony deadlines and upcoming hearing dates. Thank you, Vice Chairman.
Thank you, Ms. Jaffe. Commissioners, any questions for Ms. Jaffe?
Madam Chair.
Commissioner Irvin?
Yes, ma'am. Ms. Jaffe, I think you have an excellent suggestion here, and what I would encourage you and the attorneys to do in light of your calling this to our attention is to see if you can agree on a procedural sequencing of those hearings. Because it'd be helpful to know what you all can agree on first, rather than just having a set a procedural schedule without input. Would you agree?
I would. Thank you, Commissioner Irvin. And we will definitely reach out to all the other parties and see if we can come to an agreement on what that sequence should look like.
And since you were the one that came up with a great idea, I'm going to ask you if you would agree, consent and agree to kind of coordinate that effort and report back to us once you talk with all the parties, their attorneys, to get their input and agreement. Would you be willing to take on that task for us?
Yes, I would be. Thank you.
Thank you, Commissioner Irvin. Any other questions for Ms. Jaffe? Ms. Jaffe, thank you for your presentation and your suggestions today, and I apologize for overlooking you earlier. Parties, are anything else to bring before the commission in this proceeding? Hearing none, we will close this afternoon's proceeding and be putting this on the agenda for a motion once we receive some information or as it would deem to go forward. Hope y'all all have a good afternoon, and thank you very much for your comments and your participation this morning. And with that, we will adjourn this oral argument. Thank you.